All right, Mrs. Shuffler, your case is 25 CR 0028878A. You're charged with 2 counts of battery family violence and 1 count of simple battery family violence. You understand your rights? I assume that's a yes, Mr. Howard.
Second arrest. No, I'm sorry, third. 2025 suspended license. 2018 suspended license dismissed.
All right, thank you. Mr. Nixon?
Yes, Your Honor. Real quick, this case has actually been accepted by the district attorney's office as a felony upgrade to ag assault. And email was sent over to you with the order. It's just currently waiting on your signature. He was booked in on May 20th. So if he's apprised of his charges today, there will be no Riverside issue as long as he gets a bond in felony court before 7 p.m. tomorrow.
Okay, when was that email sent to me? Let me see. Okay, and it has it has a number, already been assigned a number as part of that acceptance.
I think it has a CR number from our accusation, but
It hasn't been assigned a PI number or a DA number yet, but that's in process.
Okay, so apparently, Mr. Shuffler, your case has been accepted by felony court. You'll be at felony first appearance at some point tomorrow. Okay? Best of luck to you, sir. I believe the case is already out of my hands.
If it's possible to hear this on bond today, that would be preferable, but
I think our policy is if it's already been accepted. And you said there's no number, Miss Allen?
Not yet, Your Honor. They can't assign a number until you sign the transfer.
Until I transfer it. Oh, well, if it's not yet transferred.
Well, technically, Your Honor, it's been accepted, it's been reviewed, it is a felony, it's been upgraded, but it can't go and get a number from the clerk until your signature is on there. The DA's office has signed off, and that's what's in your mailbox.
Understood.
We would ask to have it reset if that's the issue.
I know that's what you want, but I'm thinking about it.
The victim is here if you'd like to hear from her, and we're prepared to put the facts on the record, since that would be appropriate if we're going to have bond considered.
Of course it would. I'm just thinking if it's technically still here, I'm going to set a bond today, but I will set it based upon the fact that it has been accepted by felony. Okay, Miss Allen? The state can note their objections and I'll hear from the victim. Okay?
Please note our objection. Thank you.
All right.
At this point, it's out of this court's jurisdiction.
Well, technically, yes and no. All right. Mr. Nixon, please proceed.
yes, Your Honor. The state's going to ask for a $2,000 surety bond for count 1, battery family violence, $2,500 surety bond for count 2, battery family violence, and another $2,500 surety bond for count 3, simple battery. On May 20th, 2025, the defendant engaged in a verbal dispute with Nicole Leroy, the victim. She should be on Zoom as well. That escalated into a physical altercation over the rent money. The argument began with the defendant demanded the return of $1,600 he paid for rent. The victim responded that she would only refund the money once she had safely left the residence. The response angered the defendant, who began screaming repeatedly, "Give me my money back." The victim then challenged him to hit her, prompting the accused to push her down in both hands, causing both of them to fall to the ground. The victim tried to escape, but the defendant would not let her leave. He grabbed her head and slammed it against the wall several times, resulting in large red and purple bruises on her face and head. And additionally, the accused placed his hands around her neck and began to strangle her, nearly causing her to lose consciousness. The victim suffered severe bruising to her face, head, neck, and arms. I believe they lived together or boyfriend and girlfriend relationship for like 6 years and had lived together on and off. Our office did speak with the victim, who confirmed the events in the warrant, stated that the defendant pushed her onto the bed, placed both hands around her neck and began squeezing as hard as he could. I believe he put his whole body weight on her neck. She felt like her windpipe was crushed. He stated to her, "I will do this all day," and threatening to kill her. The victim stated that the defendant stopped strangling her when he saw her lose consciousness, and then he slapped her in the face to wake her up. She detailed how the defendant hit her so hard that she is having difficulty hearing in both of her ears. Again, the victim should be on Zoom. The state is going to ask for absolutely no further contact with the victim and stay away from the incident location, anger awareness, no alcohol, drugs, or weapons while out on bond. One additional fact to note, Your Honor, the victim stated that she's in fear of the defendant and does not want contact, and she is in the process of moving out the residence and will need until Sunday, May 25th to get all her belongings.
Okay, Ms. Leroy, if you wish to make a statement, please turn on your camera, raise your right hand. Again, I'm sounding for Ms.
Can
Leroy.
you
I
hear
need you
me?
to turn, I can hear you. I need you to turn your camera on, please. Okay, ma'am, if you want to make that statement, I need you to turn the camera on and unmute quickly.
Okay, I cannot figure out how to turn my camera on. I just received a link requesting it and it disappeared. If that could be sent again, because I would like my face to be seen.
You have to have your face be seen to make that statement. Please raise your right hand. Do you swear or affirm the testimony you give today will be the truth to the best of your knowledge?
Yes, ma'am.
All right, well, what would you like to tell me?
I just want you to see what this man did to me after 6 years of being with him on and off over some money. I understand that it was not correct for me to take it from him, but he verbally, I don't have any proof of this except for from his mouth. He verbally agreed that he understood why I hid the money from him. He understood and that it was okay. And honestly, I don't blame you, were his exact words. I'm pressing charges. I'm glad it's been upgraded to a felony because I don't ever want this to happen to anybody again. I have been in very, very many abusive relationships. And even in those relationships, I never raised my hand to a man, even in self-defense. There have been times where he and I have argued and he has begged me to beat him and hurt him because he wants that. And to the first point of him saying, he said something like I enticed him. That's what the cop said. I started telling him to hit me after he had already been hitting me. And I said, this is what you've been wanting to do it, because he was already doing it. So I don't consider that enticement if he was already in the process of swinging me around the room by my braids. I wish I could show you the back of my scalp right now. I'm missing 2 of them because he ripped them from my scalp.
I appreciate you coming to court and making that statement. All right. Mr. McLean, please proceed.
Judicial is 27 years old. I note that the area codes on both his phone number and his emergency contact phone number are local Atlanta numbers. So I believe he has plenty of local contacts. He is a general contractor, self-employed as a carpenter. He has had 3 years of college, working towards a BA degree. We would ask the court under these circumstances to consider the lowest possible surety bond if a signature bond's not in the offing, and we would suggest a range of about $2,000 surety bond. Thank you.
And Your Honor, if I might be heard.
Very briefly, Ms. Allen.
Sure. The red flags in this case that make it particularly heinous are that the documents submitted by police state that not only was this victim seen to have severe bruising to her face, neck, and arms, but specifically, the victim told the defendant she wouldn't give his money back to him from the rent because she wanted to wait until she was safely allowed to leave the residence. It also details that she was prevented from leaving the residence in addition to being assaulted and strangled. The narrative reports specifically that he placed his hands around her neck and began to strangle her. In addition, he made admissions that are documented in the police report stating he began to crash out and began to start punching the victim himself. That's what he told the police. There was also audio recorded where he is screaming at the victim, "You brought this out of me." This is a danger to this young woman, as well as, I would argue, the defendant at this point. This is now a felony, and we'd ask for a felony bond. We'd be asking for $10,000 on each of the batteries, which are really felonies, and 5 on the
You're taking Mr. Nixon's recommendations back?
I sure am. I'm the supervisor. I did the transfer. That's why I chimed in. Thank you.
Okay. All right. Defendant is going to receive a surety bond as follows: 3,000 on count one, 3,000 on count two, and 2,000 on count three for a total of what is that? 11,000?
It's
No, I'm sorry.
eight.
I'm really bad at math. 8,000.
And please let the record reflect that that is over the state's objection. Thank you.
Miss Allen, I believe we've made it clear you don't like anything I'm doing today, but we're going to keep it moving.
That's
He's to
great.
have absolutely no contact with the alleged victim. He is not to contact her via social media, phone, through a third party. If he sees her, he should turn around and walk in the absolute other direction. He is to he's to stay away from that location. He can return one time with a member of law enforcement to get any items. Additionally, he's to have no alcohol, no drugs, no weapons, and his case is being transferred. All right, best of luck to all parties concerned. This matter is now closed. Who do we have next?
Position 13, Mr. Watson.
Thanks for watching. Make sure to hit that like and subscribe button for more crazy court hearings like this one.